Hello LiveLaw viewers, welcome to Courts Today. Let us dive into the important legal headlines of the day. The Supreme Court has issued notice on YouTuber Ashish Chanchlani's plea against multiple FIRs over obscenity allegations in the India's Got Latent row. The top court has raised concerns about Delhi High Court's long orders in anticipatory bail applications. The Apex Court has issued notice to NCRB on collection of Caste-Data of prisoners. The Supreme Court has issued notice on former West Bengal Minister Partha Chatterjee's bail plea in the CBI case over cash for job scam. Former Chhattisgarh Advocate General has approached the Supreme Court for anticipatory bail in a case. Congratulating the newly qualified advocates on record, CJI Sanjeev Khanna today told them to contribute towards social work. The top court has quashed culpable homicide charges against a doctor for patient's death and directed trial for negligence. The Madras High Court has ordered opening of the temple in Villupuram sealed over caste conflicts and asked the government to act in case of law and order problems. And the Kerala High Court has denied anticipatory bail to BJP leader PC George in a hate speech case. I am your host Urvashi Chauhan, bringing you the important legal updates of today. Quick, crisp and to the point. Watch till the end, and if you find this update valuable, do not forget to like, share and subscribe. Your support keeps us going. Starting with an update from the Supreme Court, which today issued a notice on YouTuber Ashish Chanchlani's plea challenging multiple FIRs filed against him for obscenity over remarks made during an episode of the show India's Got Latent. The remarks objected to were part of an episode of comedian Samir Raina's YouTube show. YouTube celebrities Ranveer Allahabadiya, Jaspreet Singh and Apurva Makhija were also part of this episode. On 10th February, Assam police registered an FIR against the 5 YouTubers and content creators for promoting obscenity and engaging in sexually explicit and vulgar discussion. Since then, the Maharashtra Cyber Department and Jaipur Police are also reported to have registered cases in connection with the controversy. Coming back to Ashish Chanchlani's plea before the top court seeking clubbing of the FIRs registered in Guwahati and Mumbai and transfer them to Mumbai. Today, a bench of Justices Surya Kant and N. Koteshwar Singh issued notice to the respondents in this matter and tagged this along with the petition filed by co-accused Ranveer Allahabadiya. Let me tell you, initially, Chanchlani had moved the Guwahati High Court seeking anticipatory bail in connection with the Assam FIR. It was his case that the remarks for which the FIR was lodged were made by one of the guest panelists, that is Allahabadiya, and that he had no role, authority or involvement in editing or post-production of the episode. Earlier this week, he was granted interim anticipatory bail by the High Court, which also directed him to appear before the investigating officer within 10 days. While hearing a bail matter, Justice Surya Kant of the Supreme Court criticized the Delhi High Court for issuing 30 to 40-page orders while disposing of anticipatory bail pleas. He remarked that such detailed orders practically amount to conviction orders, providing reasons for the trial court to convict the accused. A bench of Justices Kant and N. Koteshwar Singh was dealing with the bail plea of a practicing surgeon in a case involving fraud and forgery charges. The Delhi High Court, in a 34-page order, denied anticipatory bail to him and his mother. In the High Court order, it called the case alarming, noting that the accused, a family including the father, mother, sons and daughter-in-law, allegedly conspired to divert and misuse company funds. The High Court had said that they acted as the alter ego of the company, effectively looting its business. It also stressed that such offences are serious and for commercial and economic world and must be treated with utmost seriousness. Additionally, the High Court also pointed out that given their close family ties, there was a strong possibility that they might withhold information to protect each other. Against the High Court order, the petitioner moved the Supreme Court. Today, his counsel, senior advocate Siddharth Luthra, submitted that it was the petitioner's father who was running the firm in question through the petitioner and his mother as proxy, and the father had been granted bail after 7 months of custody. Yet the petitioner was equated by the High Court with his father and denied anticipatory bail, even though he joined the investigation as many as 5 occasions. Hearing him, the bench issued notice to the respondent authorities and granted the petitioner interim protection from arrest. Moving ahead, the Supreme Court has issued notice to the National Crime Records Bureau to implead it as a party in the ongoing suo motu proceedings to monitor compliance with its judgment in Sukanya Santa case. In that case, the Supreme Court had directed removal of caste column from prisoners' registers and ordered that any references to caste for under trial or convicted prisoners be deleted, while observing that discrimination inside prisons based on grounds of caste, gender, and disability is illegal. The court initiated the suo motu proceedings. Dr. S. Muralidhar, who is the amicus curiae in the suo motu case, has filed an application stating that the direction to delete caste columns should not preclude the NCRB from collecting statistics on caste inside the prisons. And in November last year, the court had clarified that NCRB can continue doing this exercise. Considering this request and the need for the NCRB to file a compliance report in this regard, a bench of Justices J.B. Pardiwala and R. Madhavan issued a notice to it. Further, according to the status report filed in the court on compliance by states and union territories with the Sukanya Santa judgment, only National Capital Territory of Delhi and Chhattisgarh have yet to submit their reports. The court has given them one more week to file their affidavits. The Apex Court today issued notice on a plea filed by former West Bengal Education Minister and now MLA Partha Chatterjee seeking bail in the CBI case arising out of the state's Cash for Jobs scam. Let me help you recall that the West Bengal Cash for Jobs scam involved allegations of illegal recruitment of assistant teachers under the West Bengal Board of Primary Education. In 2022, a corruption case was registered, which led to the arrest of the chairman and secretary of West Bengal Central School Service Commission, president and secretary of West Bengal Board of Secondary Education, and of Partha Chatterjee, the minister in charge of the Higher Education and School Education Department. The accused were charged under Prevention of Corruption Act and PMLA for using their public offices for personal gain by demanding bribes in exchange for jobs at the department. Partha Chatterjee and others first sought bail from the Calcutta High Court. However, in November 2024, a division bench delivered a split verdict. The case then went to a single bench which also denied bail to them. Challenging both the split verdict and the single bench order, Chatterjee has now approached the Supreme Court. The bench of Justices Suryakant and N. Koteshwar Singh passed the order today, issuing notice. Former Advocate General of Chhattisgarh Satish Chandra Verma has approached the Supreme Court for anticipatory bail in connection with the Nagrik Apurti Nigam scam case. The state alleges that incriminating WhatsApp chats between Verma and the prime accused Anil Tuteja and Alok Shukla were recovered by the Income Tax Department and shared with the Enforcement Directorate. It is further alleged that Verma helped the accused secure bail. The bench of Justices Vikram Nath and Sandeep Mehta was hearing the SLP challenging the High Court's order denying anticipatory bail to Sharma. His anticipatory bail was also rejected by the Sessions Court last year in November. Senior Advocate Mukul Rohtagi, representing Satish Chandra Verma, argued that the former Advocate General was being targeted due to a change in government in November last year. He pointed out that the bail granted to the accused in 2019 was never challenged by the state until now. He also stated that Verma did not prepare any legal replies or appear in the case. Rohtagi further noted that the Enforcement Directorate had challenged the bail in the Supreme Court, where the matter is still pending. He said that ED under Section 66 of PMLA asked the state to register a case which led to the current proceedings against Verma. Well, during the hearing on a statement given by the Council for the State of Chhattisgarh that no coercive measures would be taken against the petitioner for 1 week, the court decided not to issue any specific orders for now. The matter will now be heard on 28th February. Stay tuned. Chief Justice of India Sanjeev Khanna today congratulated 356 newly qualified advocates on record, highlighting their responsibility in contributing to society through pro bono legal aid. The induction applications were listed before a bench comprising CJI Khanna, Justice Sanjay Kumar and Justice KV Vishwanathan. Addressing the AORs, the CJI acknowledged the diverse litigation handled by the Supreme Court, spanning family law, constitutional matters, environmental issues and consumer protection. He urged the advocates to balance professional work with social responsibility. He said, and I quote, "Please do one for your kitchen, one for the society." He also encouraged them to enroll with the Supreme Court Legal Services Committee for pro bono work. Justice K.V. Vishwanathan also extended his congratulations, stating that the AORs now have a great opportunity to carry forward the legacy of the legal profession. Moving ahead, the top court has quashed the charge of culpable homicide under Section 304 of IPC against a doctor who gave telephonic instruction to a nurse to administer an injection which led to a patient's death due to an adverse reaction. But the court has directed the trial court to proceed with the case under Section 304A of IPC, that is causing death by negligence. The maximum punishment for culpable homicide not amounting to murder under Section 304 Part 1 of IPC is up to 10 years imprisonment, a fine, or both. It is a more serious offence. Whereas the maximum punishment for death caused by negligence under Section 304A is 2 years imprisonment, a fine, or both. The High Court had refused to quash the culpable homicide case here, against which the doctor appealed to the Supreme Court. Before the Supreme Court, he argued not only that the case should fall under Section 304A, but also that the High Court had already dismissed charges against the nurse who administered the injection. Well, now the bench comprising Justices Vikram Nath and Sandeep Mehta has set aside the order of the High Court, dismissed the culpable homicide charges, and directed the trial court to proceed with the case under Section 304A. In another update, the Madras High Court has ordered reopening of the Draupadi Amman temple in Villupuram, which was sealed due to caste-related conflicts. Justice G.K. Elantirayan directed the Hindu Religious and Charitable Endowment, or the HR&CE department, to reopen the temple and instructed the government to take action against anyone attempting to disrupt law and order. The temple was sealed on 7th June 2023 after clashes arose over the entry of scheduled caste members. While members of the dominant caste opposed their entry, those from scheduled communities protested for their right to worship. As the peace talks failed, the revenue divisional officer sealed the temple to prevent violence. In March last year, the court had directed the HR&CE department to conduct pujas but had restricted public entry. Later, after another plea, the court allowed daily pujas while ensuring that reopening would not affect the rights of any party or the temple priests. Despite concerns from the collector about possible disturbances, the court ruled that religious practices should continue in the interest of the devotees. And lastly, Justice P.V. Kunhikrishnan of the Kerala High Court has dismissed the anticipatory bail plea of BJP leader P.C. George, who is accused of making hate speech against the Muslim community during a TV debate. P.C. George allegedly made remarks labeling Muslims as terrorists and communalists, stating that no Muslim in India is not a terrorist. He had suggested that they should migrate to Pakistan. A case was then filed against him under Sections 196, subsection 1, clause A and 299 of Bharatiya Nyaya Sanhita and Section 120O of the Kerala Police Act. His lawyer, senior advocate P. Vijay Bhanu, argued that George did not intend to spread hatred and that the legal provisions did not apply to his statements and that he had already apologized. However, the state opposed his bail, highlighting his past provocative remarks and disregard for previous court orders, which had earlier granted him bail under the specific condition that he should refrain from making such statements. At an earlier hearing, let me tell you, the High Court had expressed concern over his repeated violations of the court orders, questioning whether he would stop making such remarks in the future.